So he proposes his famous position as a theory of legal realism that makes him an important contributor to this tradition of legal realism. And what is the legal realistic tradition? It is a tradition that is critical of natural law and justice. It says that justice actually it's rather clear. It says that natural law, you know, the idea of a justification of law beyond a legal system, that is not the law. And it is very critical of any kind of metaphysical concept of law. It wants to say that a modernist tradition, it wants to propose a foundation of law, not in metaphysics, but in the view that valid law is what the court will do. So it's rather simple. Valid law becomes an expression of social fact. So how do you have the science of law? The science of law is to predict what the court will do. What decision making will the court be proposing? And here, of course, there's a problem because Ross was very focused on the courts as a legal authority. But maybe today we would have a broader concept of who is a decision maker within law. So the prognosis theory would have to be broader, looking at the different actors in law and the proposed decision making. But of course, this concept of valid law is not a metaphysical concept of valid law, because valid law is only what is considered as a social fact. So for those who defend a metaphysical concept of law and justice, or a more ethical concept of law and justice, this is actually the opposite thing. So in this sense, it's interesting, but it's also an attempt to make the legal system an autonomous system within a modern society. So you have this theory, and it leads to this, as you see in this next slide, that legal realism is considered as an empirical science. It's the attempt to make law a science, simply to have a scientific discipline of law. And here you see that law, according to Ross, should be an objective science without value judgment. But law cannot be understood without being an investigation of the normative ideology determining the decisions of the court. So you have concepts of within the rules, and then you have the decision making of the courts. And the problem is to apply the legal rules. There's always and here the objective ideology, the normative ideology, plays a role. What the courts? But here Ross focuses on objectivity in terms of positivism, that the normative ideology should be objectivity. And that is, of course, also the problematic point, because he calls the normative ideology a cultural tradition. And suddenly, to apply the law, you have a rather subjectivist concept of the cultural tradition. And that's where the realism the picture becomes, because cultural traditions are the normative ideology that determines the decision making of the courts. So the realistic turn of Alf Ross manifests a strong criticism of Hans Kelsen's idealistic positivism, because Ross says there's no such thing. This means that Ross develops this concept of valid law as a calculation about the future. The legal scholar is a person who predicts the legal behavior of the future. So a legal system is a sorry. The legal system is a concrete institution with socially binding directives and norms. It is defined by rules, competences, and institutions.
Hello.
So the legal system is it? Yes.
Hello, Professor. Professor
Can
Jacob,
you hear
can you
me?
hear me? I'm very sorry to interrupt you, but we're having some technical issues here, and we were wondering whether you can try to round up your discussion, your presentation, يعني in about 5 minutes, let's say, and we'll have some questions for you from the audience. I saw people taking notes all over the place, so you may have quite a few questions to answer. But can you please finish within about 5 minutes or so?
Okay, yes, I
Yeah,
will
thank you.
make it in 5 minutes. Okay, so
Thank you.
you have, I will take 5 minutes more, and then you will be asking questions. Okay, a statement about valid law is then a calculation about the future. So valid law is never a historical fact, but prediction. And that's where we go to, as I said, law is a cultural tradition. I spoke about the cultural tradition. Law is defined as an interpersonal opinion motivated by the context of legal norms. So you have the decision makers, law of the working. So law becomes a function of the working ideology of the judges. And there you have this famous statement about what is a prognosis. Is a prediction about under certain conditions, the judges will make certain decisions. So that is valid law is how it is used. And of course, here we have the famous discussion of Alf Ross, because what happens then when law becomes a descriptive legal science? Because suddenly law is not a question of justice. And here you have the famous discussion following of Alf Ross, because Alf Ross said about the law in Nazi Germany, as I can categorize a certain order as a legal order, I can see it as my highest moral duty to destroy this legal order. So the whole question then becomes, was Nazi Germany a legal order? Most people would say it is unjust, but Ross has this, but at the same time, I must say that it is unjust. And this creates this of law and politics, where the lawyer could be objective and descriptive, even though the law and legal politics cannot be separated. But it is also a question of prediction. So what is then the normativity within this theory of law? And here Ross argues for a formal consciousness of objective rules as an important aspect of the ideas. Instead of a personal subjective feeling of the judge should be guided by reference to a formal institutional consciousness of law. So, but what there is still a kind of belief that 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 this whole theory, that the legal system is an objective system, and he believes in some way that there is, in the idea of law, in modernist law, as a system of rules. He's, he sees this as a contrast to natural law, and believes that with this formalist system of law, there is something which avoids the relativity, the subjectivism, and arbitrariness of a legal system. So this legal modernism is in a way a belief in an objective legal system, as what I say below here, a formal concept of legal justice. So we can stop here. I have a few. I think I have two colleagues in Denmark who now try to develop a new legal realism as a social science approach to law. And here you have some references. I will. There's a lot of criticism of Alf Ross. I will be quick. Of course, the one is impossibility of descriptive theory of the sources of law. Secondly, there could be the yeah, I cannot take the criticism. We will jump a little bit then. So we take the conclusion, and I think Ross has done a good job in proposing law as an objective science, but this is not enough. It's good with this whole theory, and it's good to understand the importance of law as an objective science and the importance of the clear rules as being essential, so that we don't mix too much arbitrariness within the law. But on the other hand, we cannot have law without a theory of justice. And that's where we could mention another Danish scholar who I worked together with him, but he died 15 years ago, Henrik Sahle, who said that care for justice and fairness and the ability to put oneself in the place of the other, a well-functioning legal system based on a concept of validity of law. So thank you very much. I hope you have some questions.
Okay, yeah. Yes, maybe the best thing is to pass the microphone to members of the audience who have questions, and then they question to English. Is that anybody has questions?
Yes,
Oh, okay. It's only green.
thank you for your question. My question about the philosophy of law in your university or in Denmark, whether it has anything to do with the branch of action theory, which was very popular in the 60s and 70s in response to Wittgenstein's distinction between actions and events or happenings. And in that sense, that can have like a metaphysical basis for philosophy. I don't know whether this is Denmark when you talk about philosophy of action.
Yes,
I mean philosophy
I
of
can say, I can say, uh, yeah,
so
yeah, yeah. I understand very well. What should I say about this modernist approach? I think, of course, it's a approach of the 20th century, and in many ways we have moved beyond it's somebody who wants a legal system. It's a predecessor of Hart from England, and in some sense there are many similarities between Ross and Hart, because there's a belief in a system of rules create better societies, and there's a belief that law within the system of rules of law as well, where law is well formulated, the rules are coherent, and so on. There's the idea that this will create a better society, and that as such, with a well functioning legal system where you can predict the behavior of the judges and the decision makers, that this idea of the ability to predict is some way a criteria of objectivity in the legal system. So if you have the idea of action and events, the legal system can, the legal scholar and the legal system is well structured. So there's a certain social security established by the legal system. It was a legal a thinking which was based on democracy, because for Alf Ross, the basis of the legal system was democratic decision making. So the sovereign behind the legal system will always be the parliament. But of course, there are many challenges to this system, because the rights, it's not a natural right-based system, because Ross did not believe in natural rights. So in that way, you can say, could a totalitarian ruler also make such a legal system, and would it function? And here, Ross would still argue that in the rationality of the legal system, there is a certain that I think he would still believe that the rationality of the legal system, combined with a cultural tradition based on objectivity, would ensure some kind of correct application of the law. But of course, the whole problem is that he sees the legal system as a basis for justice.
Okay,
But
thank you.
and one does not want to put natural law concepts into the legal system.
Yeah,
but that could
Thank
also
you,
be argued to be a strong weakness.
Yeah, I'm sorry to interrupt, but we really have
So
very limited
that's my
time.
response.
We can take two more questions. hear you, Doctor, and then Dr. Munir, and this is it. And please, if you can keep the questions brief, and the answers also brief. We have two other speakers, and we're kind of running late, unfortunately. Okay, go ahead, Professor.
Thank you. I will try to express.
Okay, sorry. Yes, I will be short. Yes, sorry.
Okay, no problem at all. It's just that the time is pressing on us, but really we enjoyed your presentation and your answer as well. And okay, go ahead, Doctor.
Thank you. I will try to express just a point of view of a legal scholar and practitioner. It's certain that Alfred's contribution has the merit of highlighting the tautological nature of validity, to stress on one of the weaknesses of Kelsenian theory, consisting in identifying validity and bindingness. Alfred's theory has also the merit of distinguishing two concepts of validity: the validity as social fact and the validity as and the binding nature of the norm. But how Alfred Ross' theory can deal with some, may I say, practical and theoretical challenges, such as how to consider the fact, for in example, that the entry in force of norms depend on meeting some procedural requirement stipulated or defined by the norm itself. So there are two moments concerning the bindingness of the norm: the moment of entry into force of a norm, produced and enacted by Parliament, for example, and the moment of application, the judicial application of the norm. The second challenge is the question of the scope of the discretionary power given to judges, because judges, they don't have an absolute discretionary power in applying norms of validity of norms enacted Parliament. And my last question is if other alternative theories, realistic theory of interpretation as developed by Michel Tropper in France, can deal more directly with those theoretical and practical challenges. Thank you.
Okay. The question from another question from Dr. Munir, and this is with all the questions at once. Dr. Munir.
Thank you. Yes, I'll try for your presentation. My question is about the attitude of present as legal realism toward that Nazi law or part of a legal order. Emphasize the fact that I'm moved by or might be motivated by a highest moral duty that to contest. It seems for me that this is not a serious critic. I can say that Kelsen and also Herbert can subscribe at this position. And you know, though, that when there is out the position of Radbruch toward the attitude of Hart and the attitude also of Kelsen, is to say that it is legal order, and despite the fact that this legal order contradicts our justice. And this is, can also justify a kind of rejection, a kind of trial for the responsible of this law. This is good, and not part of my legal justification. This is the point that I'd like to emphasize on. And thank you.
Dr. Jacob, if you can pick up the questions and answer if you can. Go ahead.
I think with the problem of Alfred's theory, it's of course of the cultural tradition. Objective. You have the objective law enacted by Parliament, and this is a positivist moment where Kelsen has a Grundnorm. Ross has this problem of the paradox of the legislator, because who and there as a realist, uh, Ross ends with actually a theory of power, I would say, and that is of course the both the weakness and the good thing about the power and the weakness of the theory. That is very weak on the ethical justification of the legal system. So where is the justification of the legal system lies within the rules, the formality of the rules of the system, the objectivity of the system. And then, of course, you have the second problem, which is a problem of application and interpretation. And that's where he introduces this idea of the cultural tradition, where the idea is that the judge has a certain commitment to the objectivity of the legal system, and of course there is in Ross a kind of belief in the objectivity of the legal system, based on the formulation of clear rules and based on a society of rules, where the law is what you have some objective rules that means that you can predict what the judges will do. And here the cultural tradition of the judges become important. But of course, today, the cultural tradition in some way was related to a sense of justice, but the sense of justice was the ability to apply the rules of the system. And it is a belief in legal modernity. It's a belief in the system of law. And of course, today we have multicultural tradition. What does this mean for the system of law? And of course, as the other question, there was the other question where you have the problem of the Nazi regime, and of course where Kelsen talks about the ethics beyond.
In Turkey, and his research, many researches include history of political theories, humanitarian intervention, colonialism, on these subjects which I have no time to mention. So he will be talking to us and compare them to Islamic conceptions. So please, Dr.
Okay. Good morning to all. I should like to thank very much for this invitation, the Arab Center for Research and Policy Studies of Philosophy at Kuwait University, for participating in this important symposium about the philosophy of law. Baru for contributing to this invitation. The wonderful Arabic language I am not able to speak, and so I am obliged to speak English language. And the topic of my presentation will regard the question of Western and Islamic constitutionalism, in order to understand the differences between two different important. The term constitutionalism points to the existence of legal limits on the government action. Therefore, through these limitations, looking at the ways in which they are set, that we get a criterion for distinguishing between ancient and modern constitutionalism. In his book titled Constitutionalism, Ancient and Modern, Charles Howard McIlwain traces the turning point back to the age of revolutions in the 18th century, introduced by the revolution, associated by looking at the words that Thomas Paine, one of the most important scholars who analyzed the American constitutionalism, used to analyze the American Revolution. He wrote, "A constitution is a thing antecedent to a government, and the constitution of a country is not the act of its government, but of the people constituting a government." The concept of constitution in Paine's thought is that the constituent power of the people, who are in this sense sovereign and lay down the principles that will limit government action. This conception stands in contrast to that of the British constitutionalism, which locates the limit of government action in the substantive principles embodied in the institutions that have been formed over time, over the course of the history of the English people. The meaning of the Constitution is aptly expressed in its basic contours in the words of Henry St. John Bolingbroke, an exponent of the party of Tories. Bolingbroke wrote, "By constitution we mean, wherever we speak with propriety and exactness, that assemblage of laws, institutions, customs, derived from certain fixed principles of reason, directed to certain fixed objects of public good, that compose the general system according to which the community hath agreed to be governed." The Constitution is thus identified with a common law tradition, and on that basis, limits are placed on government action. In a word, and to bring this home to our own case, Constitution is the rule by which our princes ought to govern at all times. In the analysis offered by McIlwain, the two contrasting Thomas Paine's and that of the British constitutionalists reflect a distinction between a modern understanding of the word constitution and the traditional, the ancient conception, in which the word was applied only to substantive principles to be deduced from a nation's actual institutions and their development. On the modern conception, then, the Constitution comes into being the moment a constituent power is established as the foundation on which rests the Constitution itself. Ancient constitutionalism, on the other hand, identifies the Constitution with the authoritative and abiding principles that a people can look to as part of their own historical tradition. But in reality, modern constitutionalism advanced along a dual track. On the one hand, building on the experience of the American and French revolutions of the late 18th century, and on the other, solidifying the constitutional parliamentarianism that grew out of the British Civil Wars and the Glorious Revolution of the 17th century. The constitutional struggle in England was the conflict between those who saw the need to impose limits on sovereign power and those who took the opposite stance, rejecting any and all limits that had never been enforced. The struggle, as we know, ended with the Glorious Revolution of 1689, which established parliamentary sovereignty, limiting the powers of the monarchy under a system where kings as co-sovereigns. This began modern constitutionalism in England, the most prominent feature of which is identified by McIlwain with the introduction of the idea the king was accountable to the law and to the people in carrying out the activities of government. Through English constitutional history, then, two fundamental aspects of modern constitutionalism were forged: the legal limits to arbitrary power and the complete political responsibility of government to the governed. Modern constitution became fully established until the end of the 18th century, when, as mentioned, the Constitution came to be conceived as an act of the people that set the limits and manner in which government acted. Complexity of constitutionalism. The constitutionalism that came into being in 17th century England established the principle of limited government, meaning a government of laws and not of men. In the late 18th century, with the American and French Revolution, recognized the centrality of constituent power, conceived of it as a foundation of constituted powers. But it did so giving rise to two different models in those two historical constitutions. So there is not only one Constitutionalism was designed to enshrine guarantees for an already structured civil society. In France, on the other hand, it was meant to bring about a new society that would supersede the constitutional reality of the so-called ancien regime that was a regime of privileges. French constitutionalism introduced a program of social revolution, and it was the legislature that would play a central role in outlining this program. This in keeping with the principles set forth in Article 6 of the 1789 Declaration of Rights of Man and Citizen, where there is written in French word, La loi est l'expression de la volonté générale. Translated in English, the law is the expression of the general will. In the American experience, an already established civil society demanded that the governmental power be subject to a set of clearly stated limits. The United States Constitution of 1787, along with the 1791 Bill of Rights, was thus conceived as a technique for limiting the power of government through a set of protected rights enshrined in the Constitution itself. And this is the sovereignty of the Constitution, the idea of the Constitution as the supreme law of the land. But there is something else and some more. American and French constitutionalism can be understood in light of the two interpretive categories of constitutional democracy. This was the case of the United States, the first constitutional democracy, and the legislative democracy in the case of France, respectively. In the former, in the case of the United States, the superiority of the Constitution over the legislature translates into a system of guarantees ultimately entrustive to the decisive role of the Supreme Court with its power of judicial review. This principle, fundamental in a democracy, was first put into words in 1788 by Alexander Hamilton in his famous Federalist number 78, and a case called Marbury versus Madison, in an opinion written by Chief Justice John Marshall that became actual precedent. In France, by contrast, in the case of a legislative democracy, not constitutional democracy, the primacy of the legislature ruled out any possibility of introducing judicial review. And indeed, the judicial review was introduced in France only in the Constitution of the Fifth Republic in 1958. Here, the difference between the experience of French constitutionalism and American constitutionalism. In line arrived at the definition of the Constitution as the body of rules governing the relations between the holders of political power and the rights of those subject to that power, and of constitutionalism as the way in which to go about understanding the Constitution. Over the course, and here we understand the differences between the case of Europe and the case of the United States. Over the course of the 19th century, the understanding of the Constitution as the outcome of the people's constituent power gradually lost ground to the understanding of it as the outgrowth of the history and reality of a nation. A paradigm took hold that coupled
as a body of norms that develop historically in the nation's consciousness and then find a legal statement in the state statutory enacted. It is in the law of the state. This is the case of the so-called Rechtsstaat in Germany, État de droit in France, Stato di diritto in Spain, Stato di diritto in Italy. This is a European paradigm, completely different from the case of the United States. While in the United States, rights were enshrined in the Constitution.
وعلى مدار القرن التاسع عشر في أوروبا كان تأسيس الدستور اتفق أن القوانين وأن يتم القوانين الأم خلاف ذلك قانون أن يغير الدستور وفي نهاية القرن التاسع عشر بداية كان الجوهر هو كانت هو تفسير القوانين بالتعجب عند المذاهب ومجموعات في تطوير القوانين. أقوم بتدريس هذا الجزء في هذا العصر هناك تحول بين الشعب والبعد الإنسان حول ما تحت في الدستور فهي الدستور المعاصر عادة بناء على هذا التحول السريع.
Against a background of pluralism requiring the consensus of all parties. In this sense, the current constitutions can be described as a pluralistic constitution or constitution of pluralism, reflecting a plurality of political ideologies. For example, folded into the Italian Constitution of 1947 are socialist, liberal, and Catholic ideologies, exemplifying the kind of compromise that was typical of post-war constitution. From that historical reality, it follows that central to the practice of contemporary constitutionalism is the act of interpretation on the part of this interpretive act is complex. The complexity stemming from the background pluralism it is meant to solve, and in particular from the fact that in a pluralistic constitution the legal elements are merged with the moral ones, Here the most important question, which in turn means that validity
عن الحرب والسلم ومواجهة الأعداء بالطرق التي تراها مناسبة، وأنه بدون هذا الحق لن تستطيع الدولة المحافظة على نفسها استثنائية. وفي الحقيقة ظهرت هذه النظريات التي تؤكد على أهمية قوانين الاستثناء في سياق التشكيك بقدرات الأنظمة والقوانين الديمقراطية على المحافظة على أمن البلاد ومصالحها في ظروف الاستثناء والحروب وما إلى ذلك. لذلك فضلت تلك النظريات منح الحالة الاستثنائية عبر قوانين الطوارئ، خوفاً من أنه بدون تلك القوانين ستنهار حالة من الفوضى. وهذا في الحقيقة أمر مفهوم في ظل أوقات لم تكن فيها السخاء كما هي اليوم. من يسميهم كارل شميث العدو الداخلي.
Which shows that the
كلما زاد الأعداء الداخليين
becomes
وما حدث أيضا في سوريا خلال 10 سنوات الماضية. طالما أن كل شيء مباح في زمن الحروب، مو هيك؟ صبايا مين ذكرنا بالمثل كل شيء مباح؟ في الحب قانون بقانون، وأن وجود سلطة في حالة من التحرر من الالتزام بقوانين أو دستور هو وضع مخيف. أصدر هاي القوانين 1965، ويعني سماها قانون السلامة الوطنية، إنه تسمى مسميات يعني وطنية، أمنية، قومية، اسماء قال رئيس الوزراء، وكل ذلك تطبيقا لمادة تقول أن لرئيس الجمهورية الاستثنائية. في الحقيقة أريد أن أنهي يلا دقيقة. طيب أنهي بملاحظتين. الأولى لابد من المضي قدما مع جاك داريدا الذي بين أن القوانين تطاع أو لا تطاع ليس بوصفها عادلة أو غير عادلة، لا، القوانين تطاع بوصفها سلطة، وهناك من يمتلك القوة لفرضها. أما الشعور بأننا نطيع القوانين لأنها عادلة أو لنا مصلحة في طاعتها فهو مجرد خيال سياسي وليس أكثر من ذلك. القوانين عموما لا تسن لأسباب تتعلق بالعدالة والحق والمساواة، بل بوصفها تعبير عن قوة وصراعات خفية، وعلينا التنبه إلى ذلك والتمعن في السلطة والقوة القابعة خلف القوانين. في الحقيقة لا أريد أن أسير أكثر من ذلك وأقول مع البعض أن البعض يعتبر القوانين هي أدوات سلمية للحروب والصراعات. النقطة الأخيرة وسأنهي هنا، أنه على الرغم من أن قوانين الطوارئ تطبق في البلدان الديمقراطية والاستبدادية، إلا أن هناك اختلافا جوهريا أيضا علينا أن نعترف بين الحالتين، وهذا الاختلاف ليس في درجة العنف كما يتبادر إلى الذهن، وإنما في الزمن وفي الأطراف التي تقع ضحية هذه القوانين. فقوانين الطوارئ في البلدان الديمقراطية موجهة ضد أطراف خارجية، يعني بمعنى هتلر لما أعلن القوانين الاستثنائية عام 1933 ارتكب بموجبها جرائم ليس ضد الألمان إنما ضد الفلسطينيين. في البلدان الاستبدادية الطرف الذي يدفع الثمن هو الشعب نفسه، يعني يقوم الحاكم بتطبيق هذه القوانين ضد هذا الاختلاف الأول. الاختلاف الثاني هو في المدة الزمنية، يعني تفرض في البلدان الديمقراطية أحيانا أسابيع، ممكن أشهر، 3 أشهر على الأكثر يعني، بينما مثل ما حكينا في البلدان العربية تطبق أحيانا لعشرات السنوات، وأحيانا أجيال تعيش وتنشأ وتكبر وتموت في ظل هذه القوانين. وشكرا لكم.
شكرا دكتور. شكرا دكتور التزامك في الوقت. ننتقل الآن إلى المتحدث الثاني والأخير.
مجبرا دكتورة، مجبرا وليس
وأيضا عندك ربع ساعة. دكتور سماعين جلة، أستاذ العلاقات الدولية بجامعة الجزائر 3، وأستاذ مساعد بكلية الحقوق، باحث أكاديمي ومترجم، متحصل على دكتوراه العلوم في العلاقات الدولية في قسم أو من قسم الدراسات الدولية بكلية العلوم السياسية والعلاقات الجزائر. صدرت له ترجمة لعدة كتب ومقالات محكمة، وهو يعكف حاليا على في ميدان علم السياسة والدراسات الاستراتيجية.
ما هو مصدر هذه الأخلاق؟ من يعرف الأخلاق؟ هل تعرفها الدولة فتكون هي المؤسسة الأخلاقية كما نادى بذلك هيجل بالرغم ما ينطوي على ذلك من علاقات سلطوية، أم تعرف في الأفراد؟ وإذا تعرف في الأفراد سننتقل إلى الجزئي. هل الجزئي سيتكون إلى تطبيق كلي كامل؟ هنا سأتكئ كذلك على هيجل على أن الجزئية إلا إذا اجتمعت واتحدت لتأتي بنا إلى شيء كلي. في هذا المجال سنحاول من خلال تخصصي في العلاقات الدولية وفي الفلسفة السياسية سأحاول أن أناقش ما يسمى عندنا بالأمن النقدي أو بمدرسة الأمن النقدي التي أصبحت مدرسة طاغية. مدرسة الأمن النقدي، وتجسدت لها عدة مدارس: أبستريوت، مدرسة كوبنهاغن، مدرسة باريس، والآن تأسست في بيروت ما يسمى بمدرسة بيروت للأمن النقدي. كلها تتكئ على فلسفات ما بعد بنيوية، فلسفات ما بعد حداثية، تنطلق من فرانكفورت، تنطلق من كل النقدية، وبالتالي تضع على أن شروط الأمن تتحقق في الفرد بوصفها انعتاقا، emancipation، الأمن كتحرر، الأمن كانعتاق. انعتاق من ماذا؟ من مجموعة القيود المفروضة، سواء تفرضها الدولة أو سواء يفرضها التراث، سواء تفرضها التقاليد. فبالتالي كلنا نعبر عن الأمن من خلال التحرر. والتحرر هذا كيف يمارس عند الأفراد؟ عن طريق العمليات الخطابية. فأنت تتكلم بمعنى أنت تتحرر. هذه كلها عندها بعد ليبرالي، وكذلك عندها بعد ما بعد بنيوي وما إلى ذلك، أنها أصبحت تضع الدولة ليس كطرف تكاملي وإنما كطرف صراع نوعا ما، لإعادة أولا لنقد الأمن النقدي، وحتى على أنه في المقالة موجودة كيف أن الأمن السبراني ينتمي الآن إلى الواقعية، بمعنى الدول هي التي تسخر حروب سبرانية الشمالية وما إلى ذلك. حتى من الخوف الحد من تدخل الدولة، ما يسميه بالحد الأدنى للدولة. نفس الأمر ينطبق مع الرأسمالية التي تسمى الحد الأدنى للمخاطر. لذلك ميشيل فوكو لما مسألة الخوف يطرحها في طرف آخر الذي هو الدولة، ولكن لا يطرحها في الرأسمالية المحفوفة بالمخاطر. هي سنناقش مفهوم الاحتمالية، احتمال على أنك تشكل مصدر تهديد وليس على أنك قمت بالفعل. بقي دقيقة. كذلك سنتحول كذلك شخص مرتكب للجريمة أو مذنب إلى شخص يتوقع أو احتمالية خطره، وهذا بطبيعة الحال الذي وقع بالنسبة للدولة، بل هو قيد على ممارسة مهامها. فالأمن الذي تضمنه الدولة يجب أن يتم نشره وفقا لمجموعة من القرارات القانونية. ولكن يضيف ظهور دولة أمنية حيث يحظى الأمن بالأولوية القصوى لا يعني بالضمان هناك مجموعة من الضمانات على الأقل في بعض الدول. أنا كلمة ختامية على أنه سنصيغ القانون والقانون الأمني وفقا لما نضعه من تعريف للأمن ووفق تعريف للحرية. هذا أولا. الأمر الثاني على أننا داخل هذا المجال علاقة الأمن بالقانون ولا أمن، أمن الدولة الذي تصيغه هو عقلانية كلية، بينما لو ننتقل إلى أمن الأفراد كما يعرفه الأمن النقدي سننتقل إلى عقلانية مجزأة. وهنا كذلك سأشير إلى كلمة أخيرة وأختم. الكلمة الأخيرة وهي لهيجل كتحرر. يقول هيجل: لا يمكن صياغة قانون عن طريق قانون عقلي. وشكرا جزيلا.
شكرا دكتور اسماعيل. افتح باب النقاش، الرجاء ايضا الالتزام من الجمهور اللي عنده الميكروفون لو سمحتي هني. الاثنين. اوكي. دكتور جوستاف ممكن كان في بعد دكتور منو؟ مترجم. اوكي. So we will open the questions الحين. Okay, so we'll take questions for 3 بس 3 أشخاص صح؟ اوكي. for دكتور جوستاف والدكتور اسماعيل والدكتور رشيد. رجاء الاختصار. تفضل دكتور.
باختصار شديد. Short question to Professor Gozzi. This is the comparison between the Anglo-Saxon systems.
The questions for you. He's asking a question.
And the Latin jurisprudence. This is in one aspect. This is a great difference. This is the problem of individualization. Individualization, judicial individualization, and in the justice and in the administration. We have the difference between the sentence and the verdict. And there is the great difference between the two systems in Europe and the United States. This is the great problem. Yes, yes. يعني بالعربي هناك تفريد، والتفريد هناك تفريد قضائي وتفريد إداري. ومثلا في التفريد القضائي ممكن القضاة ولكن في الولايات المتحدة الأمريكية يمكن لرئيس السجن أن يطلق سراح المحكوم. ما هو تأثير ذلك على الدول العربية؟ هل يمكن أن نستفيد من هذا التمييز بين المنظومة الشديد الأستاذ رشيد في العدو الداخلي؟ العدو الداخلي اليوم هناك قاضي وفيلسوف أمريكي جونتر جاكوب خلق مفهوم فايند ريشت، يعني القانون الخاص بالعدو، واعتبر أن أي شخص ضد الدولة فهو عدو. هذا السؤال.
أوكي، شكرا لك.
السؤال الثالث بسيط جدا، يعني هو المسألة متعلقة بالأمن السبراني والأمن في العادي، يعني في الحياة اليومية. المشكل الكبير المطروح وهو الانالوجي بين the two، يعني نقوم يعني الدولة نخلق قوانين، مش نخلق فقط تطبق القوانين العادية على الأمن السبراني، رغم أن المقارنة، رغم أن الانالوجي غير قانونية. لا يجب الاعتماد على الانالوجي، بل يجب الاعتماد على قوانين جديدة. يعني أليس هناك ضربون للأمن الخاص بي؟ أنا ممكن في أي لحظة أن أحاكم، لأنني يمكن أن أي شيء أكتبه يمكن أن يحاسب ضدي.
شكرا. نأخذ الأسئلة، تفضل. نأخذ كل الأسئلة ثم الإجابات، رجاء الاختصار من الجميع. نعم، تفضل.
شكرا. أود فقط يعني إثارة انتباه من منظور العلوم القانونية، هو أننا عادة ما نستعمل يعني مصطلح الحالات غير العادية، وذلك لتغطية عدد من التوصيفات، يعني فيها حالة الاستثناء وحالة الطوارئ وحالة الحصار وحالة الحرب. ولكن بغض النظر على التوضيح لتمييز على الأقل بين 4 فئات، أود يعني أن أعرف رأي زميل الدكتور رشيد الحاج صالح بخصوص فئة جديدة من حالات الطوارئ، هي حالة الطوارئ الصحية ناجمة عن جائحة كوفيد-19. يعني هل ده في إطارها هذا من تنظيمات قانونية، وأيضا يعني من حالات يعني لتنظيم وربما تقييد ممارسة بعض الحريات العامة، يعني يندرج عادية، أو أن هذا التصور النظري الشامل للحالات غير العادية هو بحاجة إلى إعادة نظر على ضوء فئة جديدة طوارئ، هي حالة طوارئ صحية، والتي يكون فيها نوع من يعني متطلب توازن بين حماية الصحة العامة من جهة، وبين تنظيم وربما تقييد بعض الحريات من جهة ثانية.
شكرا. أنا سؤالي بسيط ومباشر للأستاذ إسماعيل. عندما نقرر قراءة فلسفة القانون على ضوء باراديغم الأمن كما فعل بعض منظري هذه الفلسفة، أنت ذكرت جون جاك شيفاليي، أليس هناك خطر على هذه الفلسفة من الاندحار إلى أن تتحول منظومة لتسويغ وتبرير سلطة الدولة؟ هناك منظرين آخرين لفلسفة القانون، وأعطيك بونوا فريدمان مثلا، يعتبر أن الفرق الجوهري بين الفلسفة السياسية وفلسفة القانون أن الفلسفة السياسية مدارها على سلطة الدولة البوزقة، ومدارها على العدل، وإن كانت تقر بأنه من الضروري الخضوع لسلطة الدولة وللقانون، فيجب أن نخضع في تقدير باراديغم الأمن سيف ذو حدين. ينبهون على الحاجة إلى هذا الأمن، وهذه مسألة معروفة في تاريخ النظريات السياسية، ولكن قد يقتل في القانون نفسه معنى القانون الذي هو بحث عن العدالة. إذن ما هي أهمية ولكن أيضا خطورة باراديغم الأمن على فلسفة القانون؟
شكرا دكتور، تفضل.
شكرا. بالنسبة للقوانين الاستثنائية وحالة الطوارئ، هل يمكن القول بأن السياسة تغلبت على القانون بناء على فكرة مثلا حنا أرنت بتحويل الغايات إلى الوسائل؟ وسؤال إلى رشيد عفوا اسماعيل جلة، هل يمكن القول بأن فكرة الخوف انطباع سيكولوجي هو الذي جعل الأمن يتغلب على الحرية أو التضحية بالحرية من أجل الأمن؟ شكرا.
شكرا. في سؤال بعد وراء، تفضل.
Thank you. I have two questions, one for Professor Gustavo and the other one for Dr. Rashid Haj Saleh. I'm so happy that we're asking them together because the contrast between their papers brings a lot of questions to mind. Dr. Gustavo, given the critical role of constituent power in shaping the constitutional frameworks of both the United States and France, how do these historical insights help us understand the challenges facing constitutional amendment today? To give you the context I'm asking this question from is that after the Arab Spring, the only thing that have been changing is the constitution. So my question is, what makes a good constituent power? السؤال الآخر للدكتور رشيد. دكتور رشيد، ألا تظن بأنه محاولة الفصل بين وطالما نحن لسنا من يمتلك السلطة هو عملية هزيمة أمام خطاب السلطة، وهون بتيجي امتياز أنه جامعة الكويت ودورية تبين يعملوا ندوة حول فلسفة القانون، لأنه من خلال الدفاع عن الحاجة لإنتاج خطاب قانوني نرفض الاعتراف بأنه القانون هو مجرد ملك للسلطة. وفي هذا السياق بتخيل بقدر أفهم مداخلات كل من نبيل وجايكوب في الدفاع عن المداخلة الوضعانية بالسياق العربي. شكرا.
Gustav, you can start first. 3 minutes to answer the question. كل واحد 3 دقائق.
Thank you. Many thanks for the first question that you have asked me. I've discussed about constitutionalism. The definition that we can give of constitutionalism is a technique of separation of powers, of guaranteeing rights. But